Continuation of dissolution and winding up of partnership. So, hello everyone, good afternoon. I am Daramilda Maria Laurio. So, to continue what the last reporter next is by the insolvency of any partner. Insolvency here means that the liabilities are greater than the asset. We all know that the solvent the business, the higher profitability. So, the partnership is subjected to judicial dissolution if the partner is or the partners has many liabilities compared to the asset contributed to the capital, the overall capital of the business. Next slide. So, for the last, which is the civil interdiction of any partner. So what is a civil interdiction? It deprives the offender during the time of his sentence of the right to manage his property by dispose of such property by any actor, any conveyance, inter vivos. Or simply it talks about the legal restraint upon a person incapable of managing his estate because of mental capacity or disability, from signing any deed or doing any action to his own prejudice without the consent of his curator or indictator. So Article 1831. On application by or for partner, the court shall decree a dissolution whenever first is a partner has been declared insane in any judicial proceeding or is shown to be unsound in mind. This only talks about the presumption is in favor of sanity. That is why the insanity here must be duly proven on court. Take note that the insanity will make a person incapacitated to enter into a contract like a contract of partnership. So, the mental capacity or abilities of a person to enter a partnership. Second is a partner becomes in any other way incapable of performing his part of the partnership contract. For example, in the book, it said that A, B, and C formed ABC partnership to engage in the private practice of law. Subsequently, C applied and was appointed as government legal officer, and C was not given the authority by their head of office to engage in the practice of law. Thus, in this case, C is incapable of performing his part of the partnership contract. So how can partner C fulfill his responsibility if his authority over the partnership has been has been has not allowed, or his power has been taken by the head, so he cannot exercise his responsibility at all, the partner. So that makes him incapable of performing his part in the partnership contract. So he will be subject to judicial dissolution. Next is a partner has been guilty of such conduct as tends to affect prejudicially the carrying on of the business. Next, a partner willfully or persistently commits a breach of the partnership agreement or otherwise so conducts himself in the matters relating to the partnership business that is not reasonably practicable to carry on the business in the partnership with him. As simple as it is po, an example is yung partnership nga po ni A, B, and C. Subsequently, C became regularly drunk with liquor that causes his habitual tardiness and absences their, from their office despite of warnings from A and B. Before the punishment naman po may warning, but the partner C, naging habit niya na uminom to the fact that he became irresponsible for his duties. So yeah, that that partner is subject to judicial dissolution. Fifth is the business of the partnership can only be carried on a loss. Take note that the intention and essence of every business partnership is to divide the profits among themselves. As simply as it is po, the partners or partner cannot be or cannot risk their profit at a loss po since the division of the profit is naman po equally. There should not be a problem in the po contribution or the distributed money to them. Wala po dapat na malulos sa capital mismo. Lastly is other circumstances render a dissolution equitable. According to the book, this is a catch-all provision for other grounds of judicial dissolution not mentioned above so long as this can be proven in the court. Other than the fifth po, so other circumstances that will subject to judicial dissolution can render to a dissolution equitable po. Note is there can be judicial dissolution if the continuation of the partnership has become inequitable na nga po. Yung sinasabi nga po sa last part which is wala na pong contributed si partner at all. Next is, on the application of the purchaser of a partner's interest under Article 1813 or 1814. If babalikan po yung previous reporters, so, there are two. After the termination of the specified term or particular undertaking. And next is at any time if the partnership was a partnership at will when the interest was signed or when the charging order was issued. It only talks about the application of a new partner after the termination of the ex-partner. So, next slide is who can sue for judicial dissolution. Kanina pa nga po natin pinag-uusapan yung judicial dissolution. So, going back, what is a judicial dissolution nga po ulit? It is sometimes called as the corporate death penalty, wherein a legal procedure in which a corp is forced to dissolve or cease to exist. Who can sue for judicial dissolution? First, a partner or any of the 1 to 6 grounds for judicial dissolution in the first paragraph. The 6 grounds I mentioned earlier, if that partner has a characteristic from those, technically, he or she can be sued for judicial dissolution. Lastly, the purchaser of the partner's interest in the partnership under Article 1813 or 1814 after the termination of the specified term or particular undertaking or if the at will when the interest was assigned or when the charging order was issued. As simply of that po, yung bago pong kukuha doon sa inalisan ni terminated partner, he or she can be sued for judicial dissolution if found there has been tricks or illegal or hidden motives in taking over the terminated or ex-partner po. So that's it all po. Thank you for listening. I hope you learn from me, something from me. Sorry for the voice. I'm sick these days po. Thank you and God bless. Keep safe po.